Welcome back. In this lecture, we take up the question of legal systems. Now, the law has a couple of basic functions. The law is there to regulate relationships, and it regulates two different types of relationships. It regulates the interactions between the state and the citizen, so the relationship between the state and its citizens, and it also regulates the relationships between the citizens themselves, the private citizens. In the law, we tend to break this down into public law and private law, but it's interesting in that every legal system in the world must address these two needs. So what is the role of the law? The law is there to regulate relationships between the state and its citizens and between the citizens themselves. Now, as I said, every state has its own legal system. Throughout the world, there are hundreds of legal systems. However, these legal systems tend to break down into certain categories. And the study of different legal systems is known as comparative law. And that's the topic that we'll be looking at in this next section. Now we're going to start with how do the world's legal systems compare? Well, as I said, every state struggles with the same issues: marriage, divorce, inheritance, business relations, torts. All of these legal issues exist throughout the world. So the question is, how does a state address them? And they address them by adopting a legal system. Countries need a means of dealing with this problem, and that's what the law does. That's why the law is important. The law is how we handle those particular issues. Now, as I said, there are hundreds of legal systems, but they can be categorized in different ways. First of all, there are two broad divisions of legal systems, and that would be a religious legal system, which originates from a deity, which consists of laws imposed by a higher authority. And then there are secular legal systems, which contain law as originating from the people themselves. Secular legal systems are based on man-made law. And the idea is that man has discovered over the course of years of society how to live with one another, and therefore man has put those rules into existence. So a secular legal system. Now there's other ways of categorizing legal systems, and that's what we're going to focus on in the next part of the lecture. We're going to look at 5 different ways of classifying legal systems, and we'll spend most of our time on the first 3. The first is known as the civil law. The second is the common law. The third is Islamic law, or also known as Sharia law. The fourth is customary law. And the fifth is mixed legal systems. Now, we're not going to spend a lot of time on custom and mixed legal systems. However, we'll focus on those first 3 types of systems: the civil law, the common law, and Islamic law. We start with the civil law. What is the civil law? Well, the civil law is the oldest and most influential of all legal systems. It's also the most widespread and used throughout the world. Now, whenever we talk about the civil law, in essence what we're talking about is a law that is codified systematically, meaning the general law exists, but it is broken down into topical areas, and it is systematically organized and kept. The civil law originated from Roman law and based in large part on Roman heritage. Your textbook will explain the Justinian Code that the Emperor Justinian imposed and what exists as the first example of civil law. However, most civil law systems today date from the French Civil Code, the original Code Napoleon, the code that Napoleon Bonaparte oversaw the production of. Some historians have said that the French Civil Code is probably the most influential document in the history of the world. That's how important the French Civil Code is. The French Civil Code emphasized, really for the first time, a clearly written and accessible form of the law. There's a great preference in the civil law for writing. Therefore, the law, if it's a law, should be written down somewhere. And that law should be accessible. Accessible not just to legal professionals and legal scholars, but to anyone who wants to know what the law is. So accessibility plays a huge role. This is why this civil code is organized topically, systematically, so that it is accessible. If you want to know what is the law about landlord and tenant, or you want to know what is the law about inheritance, you go to that section of the Civil Code, and the Civil Code articles break it down for you and explain exactly what the law says. Now, as I said, the civil law gives precedence to written law, and the civil law is the most widespread of all legal systems. Civil law is found throughout Europe, with the exception of the United Kingdom and Ireland. Most of Latin America uses the civil law. Both Central and South America use the civil law. The civil law is found in many Asian countries and many African jurisdictions as well, especially those African jurisdictions that were previously French colonies, especially those African systems that were European colonies. The civil law systems share certain characteristics. Civil law systems, first of all, are secular. There's no need for a higher authority in civil law. There is no looking to some sort of supreme lawgiver to give the law. The civil law acknowledges that the law comes from people, comes from man. Matter of fact, the first article of the Louisiana Civil Code, Louisiana being the only state that is based on a civil code system. Louisiana has its own civil code. The first article of the Louisiana Civil Code actually says that legislation reflects the solemn will of the people and therefore is the primary source of the law. So the law, as created by the legislature, is the highest form of the law. It's very secular. Civil law systems are also capitalist. There is an underlying economic aspect to civil law systems that tends to be capitalistic oriented. Civil law systems rely almost exclusively on written sources of the law. Sources of the law that are not written are discounted and of very little use. The worldview of civil law systems, it's fair to say, is that it is state-centered, meaning there is no division between the law and the state. The state is the entity that creates the law. As we'll see when we'll talk about common law, that's not a common view in common law jurisdictions like the United States. In the United States, we tend to think of the law being separate from the government, that the government and the law exist in different realms. But in a civil law system, the law and the government are the same thing. So for a civil law scholar, it would not do to speak about the law that exists outside of the government. There is no law there. Now, the law in a civil law system is primarily seen as a means of resolving disputes authoritatively. And in a civil law system, the administration and enforcement of the law is primarily handled by professional actors, by judges, or by lawyers, by individuals trained in the law. So the principal actor in a civil law system is going to be professionals, those that are trained in the law. One becomes a judge in civil law systems not by being a good lawyer or friend or running for election. You study the law. You study how to be a judge. It's a professional role that is something you train for. There's no jury system, a group of amateurs that come together to decide a legal issue. That concept doesn't exist in the civil law. So that's a little bit on the civil law. In the next topic, we'll look at the common law.